Mr. Hicks, you're taking us through the correspondence,
Yes.
which is fine. I understand that, but we have read it, and are,
well,
I think, pretty familiar with the thrust of it. So
Yes.
by all means, draw attention to any particular points. But otherwise, I think you can really go on to your substantive submissions.
I'll try to take it through as more of a gallop than a trot, certainly. But I think there are some key points, especially.
By all means, make the key points. But there we go.
Very well. Well, in which case, if we could take up B. So this is the supplemental bundle B144.
Yes.
This is a letter. It's 14th of September from John Cameron of Bowser's to Julie. This deals with some updating witness statements, but it's the final paragraph, and this is the one where this is the offer of compromise from Bowser's, and what they say is slightly different, I think, to what's been said already. It says, our client has also instructed us to ask whether, in principle, you would consent to your removal as executor if a new co-trustee were to be appointed to administer the ongoing trusts that will arise as a result of the number of the beneficiaries currently being minors. If you confirm this would be the case, then our client will make inquiries of suitable candidates. 2 points arising. First of all, it was not a proposal that a co-executor would come in. It's very clear this is a co-trustee. And that's obviously problematic when you've got a 1975 Act claim, which is likely to result in complete rewriting and an exploration of the trusts going forward anyway. That's just really it's an issue that's probably going to be overtaken by events anyway. But it certainly leaves Mr. Bowser in as sole executor. And the second point is, it's just I suppose it's almost a matter of irony in the submission, that they say this: if you confirm that this would be the case, then our client will make inquiries of suitable candidates, which underlines the point I think your lordships have already made, that if one is talking about appointing an independent, first of all you agree in principle to do so, and then you might go on and talk about candidates. There's no point in talking about candidates until you've agreed the principle. Well, that's exactly what Bowser's were proposing here. So coming back to the suggestion that my client or her solicitor should be criticised for not having put forward candidates when the principle of an independent executor being appointed had not been conceded by Mr. Bowser. The boot is rather on the other foot here. It's clear that there's nothing in that point. It was a matter of half an hour at the hearing to thrash out a name that we could agree, and it should not have taken. This was not an insuperable objection. To the key question was always going to be the principle. Will you agree to an independent? Yes, right. Well, then it doesn't take a genius to work out somebody who's suitable, and that's exactly what they were proposing here. I do need to sort of pause in the correspondence here for a very little backtrack, because in the meantime to all this being going on, there is an issue. Your lordships may have picked it up in the papers about some papers and cattle passports which supposedly were being held by the police. Now, that's an issue that wasn't initially raised in the claim. The claim was not on the basis that Julie was refusing to release those papers, and it might just be helpful just to spend 1 or 2 moments looking at how that issue arose, if that's a matter of concern. As your lordships will see, when Ashton's came on board, almost the first thing they did was say, well, look, if you really need these, if you need us to consent to these papers, fine, have them. We don't accept that we've done anything wrong here, but if that's a problem, have them. And in fact, if one goes through the correspondence on that point, really, there's nothing in it. Just very briefly, it's at B30 in the supplemental bundle. Is the start of the correspondence, and I say I will take this through as a bit of a gallop. B30 is a letter from Bowser.
Please do, because this does sound a bit peripheral to me.
The simple point I wish to make is, so we have a 28th of June, Bowser's writes to the police saying, what have you got? The police reply over the page B31 with a list of possessions. Basically, it's what Ian had on him when he died. Things like the clothing that was cut off when he was in the car accident, the contents of his wallet, and things like that. There's no mention of any paperwork in the nature of cattle passports here. There follows, and if one skips to B43, there was a. Sorry, there's some further requests, but it's sorry, B46. Bowser's writes to DP Legal on the 19th of August, which was a Friday, stating that there were some items belonging to Mr. Smith that are in possession of the Cambridgeshire Constabulary, including animal passports and other paperwork. So we're not quite sure where that comes from, because it's not mentioned by the police. The documents required to run the farm. We'd be grateful if you could please confirm whether your client would agree for all items belonging to Mr. Smith to be released to our client. If not, would she agree for cattle passports and other items relating to the farm to be released either to our client or Jack Smith? Now, by the following Wednesday, I think, with the correspondents have proceeded to that's at one. So it comes back into the correspondence. Yes. So that brings us back into the correspondence on the 24th of August, which was, I think, the following Wednesday. They were asking for an urgent hearing, as they'd not heard, and raised the question for the release of these papers. So, but insofar as there was an issue about this, I mean, they'd barely given Julie any time. They'd barely given the DP Legal any time to write to Julie to ask her what she had to say about it all. Were writing straight off to the court without a chaser. And as I say, once Ashton's came on board, as they did, the statement exhibiting this was Mr. Cameron's statement. Was served in mid-September. When Ashton's came on board, they looked at this and, say, as we'll see in the correspondence, agreed to the release. So we said there really is nothing to see here. It's a simple question of communication. If this is really that important, why didn't they? They could have just said, look, please answer our question. It is really important. There's an issue here. And as happened, it would have been agreed to be released. So there really is nothing to see there, insofar as it's relevant at all. The next key piece of evidence is, of course, Julie's witness statement, which comes in. I'm sure your lordships will have read it. It is unfortunately, as we've seen, that unfortunately it doesn't seem to have photocopied quite as well as it should have. But the key, and the statement starts at B50 in the supplemental bundle, but it's at paragraph 19 at B54, which I'm sure your lordships have, because I think it's been referred to already, have seen, which is where Julie says she is content to step down as executor.
Well, what she says is that she's already said that in an email.
Yes.
Have we got that email?
I haven't seen that email. It may have been from DP Legal.
Well, it was.
Yes, but I think DP Legal had said that the one I've seen from them says we're discussing it. Would Mr. Bowser agree to an alternative? But I haven't seen that email. But
Bowser's at page 145 say they don't know what that's about either, and they ask for it, but we don't seem to have it.
The fact is, she is making it perfectly clear she is willing to step down as executor, but at 21. And it's an important but. I'm firmly of the view that Mr. Bowser is not the appropriate person to be dealing with the estate on his own. So I'm concerned that without an independent party being aware of the dealings of the estate, it will be administered inappropriately and to the disadvantage of any future application that I may make on behalf of myself and the children. We say it's pretty clear from that her position is that he's got to go, and she will go if he goes. And certainly anyone reading that would see that as the obvious solution to this case. She's got an objection to him. She disputes the claim. She hasn't agreed. She hasn't accepted that she's conflicted or that she's done anything wrong. But she says he should go. And that's the position that was adopted in correspondence thereafter. Again, as I say, the obvious solution is that they simply both go, and it was flagged at that stage. The next key bit of correspondence is at B145, which is Mr. Cameron's response to Julie having seen her statement. In which he basically says, you've got to concede the application. You have no strong wish to remain as executor. The claims against our client are denied. And if you don't go, the court will order costs against you. And they will respond to the end of the penultimate paragraph. If you continue to refuse to consent to the application, we'll have to prepare a response to the allegations that you've put forward in your witness statement, which will mean more costs for the estate to pay. Again, there's no indication here that the common sense the common sense solution of just backing down, taking the heat out of the situation and agreeing simply to appoint an independent to avoid all those costs was to be adopted. What possible benefit could it be to the beneficiaries to incur those further costs when the obvious option was for him to stand down? Now, Ashtons are instructed in late September. The first email is at 147 when Miss Stevens introduces herself. And what you'll see from her opening email, she is referring to trying to narrow the issues. That's what she's seeking to do, not to create further conflict, but to try to resolve matters. And then we get to the important first significant email of the 5th of October, which is at B151. There is a substantial request for documentation, which, in a sense, dealing with the estate. She asks a number of questions. In particular, and this is the second paragraph, it's about 3 lines. In order for me to assist Julie and to work with you in order to resolve the issues between the parties, work with you to resolve the issues between the parties are important words. I need a better understanding of not only the assets and liabilities within the estate, but also their current use and any potential risk to those assets. You see, there's a farm, and they need to understand what is going on there. As I say, there's various requests for information. Importantly, over the page at point 8, the point in relation to the request for the file in relation to 73 and 75 is made there. At 10, she's asking for details of occupation of the former family home and its current condition. Mr. Bowser gives evidence of part of its conversion into a butchery. Please, can you explain how this has been done and who's paid for this? Can Mr. Bowser please confirm what had been done? Given his evidence, it appears to have been that he has been to the house. So she's asking questions about that. The next paragraph, about halfway down, deals with the question of the family home. She explains the use of the former family home as a butchery or abattoir must not continue. The cost of putting the property back into a habitable condition will be high, and of course utterly unavoidable, and the conversion of the house into anything other than the home will be highly prejudicial to the children. And she is concerned that, Julie is concerned that unauthorised or unapproved use of the farm might give rise to further proceedings. But I think rather most importantly is the penultimate paragraph on 153, in which she says, I appreciate that you will be alert to the fact that it is therefore absolutely imperative that both sides work together in a collaborative way, as is possible, in order to ensure that the estate is preserved for the children's future. That means that we need to prevent the entrenchment of positions and facilitate the early exchange of information to narrow the issues and achieve resolution. And that's clearly an indication that she is willing to talk, try to resolve matters, not to create new issues. The response at 154 from Bowser's is pretty clear. Second paragraph, while there's a live application for the court to consider to remove your client from her position, there is no purpose in your client running up large bills in relation to the administration of the estate. The current court application must be dealt with first. Of course, there's no must about it, because if in fact information can be provided and a swift settlement of the 75 Act claim can be reached, arguably the whole thing falls away anyway. That was a perfectly sensible way of trying to proceed, because of course all the estate needs to do is provide the information, and then Julie can negotiate with the beneficiaries. The minor children are in fact represented by her brother in these negotiations, who's instructed Burkitt Long. So there's a litigation friend and solicitors all ready to go if we get that far. It may just be for an approval of a settlement, but we'll see. But there's certainly good common sense in trying to resolve the matter that way. It certainly doesn't follow that, of course, they weren't concerned about the current litigation. But the position clearly from this letter is your client is unable to fulfil her duties as executive property as she is conflicted. So it's the conflict that is being relied on here, not any deadlock or anything like that. They raised the point about animal passports in this correspondence.
Well, your point is that throughout their position is she's got to go.
Yeah.
When it comes to that, doesn't it?
And but not me. I'm not prepared to back down. She must go.
All right. Well, I think we've got that.
Yeah. No. Okay. Okay. Well, Okay. Well, please, if I may, just take you just to a couple more bits of the correspondence, because again, I'm sure you will have read this in a lot of detail.
Well, can you just give us the page numbers, perhaps?
So 172 is the next substantive one, which is the 7th of October letter. There's a couple of points which are important to draw your attention to. Obviously, this is generally a very important letter. At 173, second paragraph up from the bottom, about 4 lines up, there's a note about it. It is, of course, open to the parties to agree to allow Julie and the children to move back to the house now so they can begin to rebuild their lives in familiar surroundings. This should be our focus, not the proceedings which are currently before the court, which were issued 2 months ago as an urgent application in which quite obviously are nothing of the sort. So that's very clear that Julie was concerned to get the children back into the house. Now, it's been suggested by my learned friend that, in fact, that was also something of great concern to Mr. Bowser. In fact, that's not what his witness evidence says at all. His witness evidence says that he was concerned to preserve Jack's fledgling business, as he refers to it, and that this was a problem and effectively stood in the way of Julie moving back. But certainly, in light of that letter, if he was concerned for Julie's and the children's welfare and to get them back into the house, well, there was the golden opportunity to do it. She wanted to go back in, and between them, they certainly had the ability to get her back in. But nothing happened on that front. They're still not back in. I think fingers crossed, I think it will be tomorrow that they will be moving back in, but only after a long, long delay. Just another short point at 174, second paragraph down. They explain, second line, there's no urgent need to remove Julie as executor, and as we said above, there is in fact inherent sense in her remaining, in that her position, given that she is the mother of the children, who will be represented by a litigation friend, and that she has considerable knowledge of the farm, having assisted Ian during their marriage. She had 20 years' experience of running a farm. So making it perfectly clear that she was not proposing to act as litigation friend. Obviously, somebody else would be acting in that regard, but she was also perfectly willing to run the farm. But the final paragraph at 177, and this is again very important, the potential costs of all this are highly prejudicial to the estate. Accordingly, we welcome discussions to see how this litigation can be best settled in a manner which will be in the best interests of both parties, and more importantly, the beneficiaries of the estate. That's not to sweep the litigation away or under the carpet. They're inviting settlement. And there's already effectively a proposal on the table that Julie will go if he goes. Bowser's response at 178, Your Lordship, I don't propose to take you through that in any particular detail, save to note at 180, and there is at 180 at paragraph 1, and there's the numbered paragraphs 1 and 2. They suggest Mr. Bowser is unable to step down as executor without an order of the court. Now, that may be correct, but they suggest stepping down would be a breach of his obligations as executor. But of course, the simple answer to that is if a consent order can be agreed and approved, it won't be. But paragraph 2 deals with the sort of various minor issues that have been raised. But one can see when one reads this that the actual objection is not so much those things in themselves, but the fact that Julie was doing it in circumstances in which they perceived that she was conflicted. But there is no indication in this letter of any willingness to negotiate or compromise. The correspondence continues. 185 is the letter of the 20th October, in which Ashtons complain about the tone and content of the correspondence. Particularly 186, 3 paragraphs up. Second paragraph. We feel the tone and content of your letter demonstrates a lack of neutrality and impartiality, which is misplaced and unhelpful, as is the request that we respond to 24 hours. We are happy to work with you to identify the best way in which to proceed so that this matter is conducted in the best interest of the beneficiaries. The current litigation will achieve little positive and will serve to create unnecessary costs which the estate can ill afford. Again, here is Ashtons pleading with them to try to resolve this without the need to go to court. And yet, Bowser's again are intransigent at 187. They will not back down. They insist that the claim proceed. And then we have the 189 letter. This 189, the letter of 25th October. This is very important because, as in its second paragraph, is critical. Ashtons again repeat the proposal that Julie and Mr. Bowser step down. That's the basis of Julie's defence. They should both go. That's her open position, and it's and that is with the benefit of legal advice that is the position she wishes to take. And they can't understand why it is so urgent to press this for what was effectively an interim injunction hearing. Again, I would ask your lordships to read that correspondence carefully. The response to this letter, which was on the 25th of October, is at 192, where Bowser's say, essentially, we're now going to press to have this matter listed. And listed it was the following week.
Well, they say the only way out of the dock is to move forward with our client's application. So they're rejecting the proposal for both of them to stand down.
Yes, that's absolutely clear. That is absolutely clear. And your lordship, I don't know if your lordships have read the transcript of the hearing. Much of it is neither here nor there, but I think it is important to know how the case was put. It's in the core bundle at, I don't know if it's my tab 8, but it's A73.
Sorry. Before we do that, can I just clarify? I mean, I take it that the application was then heard in my day, it would have been called the Chancery Applications Court.
Yes,
that's all right.
Yes.
And so it came before Mrs. Justice Bacon on a day when she presumably had lots of other things to deal with.
Well, at least she was lucky if she didn't say how busy she was on that day.
Yes.
I can't remember.
She did. She
definitely had other things.
She had at least one other hearing.
Yeah. Well.
Yes.
In any event, but it was listed as a in the ordinary list, not as a not as a special hearing,
and to be heard with evidence. Well, there was obviously evidence with the application.
What do you mean with evidence?
Well, in the sense that there was a bundle of evidence of all the witness statements, correspondence.
Sorry,
No. Sorry, I'm not being.
You don't mean with oral evidence?
No, there was no oral evidence. There's no suggestion of oral evidence, but of course it had to be heard on evidence.
Obviously,
which was before the court. Now,
she said it starts at 10:30 at page 84. There's an adjournment where she's going to deal with other matters.
Yes.
Then you come back in and it goes on till 12:45.
Well, the point I wish to make at A74.
Just before we get to look at that, your case is the obvious solution was both set down.
Yeah.
I couldn't find any reference to that in your skeleton for this hearing.
The hearing on the
hearing before Mrs. Justice Bacon.
Well, no, that was rather our proposal for resolving it. It was not quite without prejudice, but.
Well, it was an open offer, but.
Yes. No, I consider
I would have thought you might have made the submission in your skeleton. This is the obvious solution, but I mean, it's not. Well, not there.
I mean, I think our position. Yes, our position was we would go if he went. But I think our concern at that hearing was rather to defend the application as it stood against us. I didn't actually get a chance to make any submissions on the substantive application because, of course, it was overtaken by events. But yes, that was our position. I mean, I thought it was clear from the correspondence that that was our position.
Yeah. Okay.
But it's just the way it was opened at A74 at sort of point. It's the first sort of up down to about the second hole punch. My learned friend at C, when asked why should it be the claimant, not the defendant, who takes unilateral control, says for two reasons. The principal reason is that before the testator died, he and the defendant were involved in financial remedy proceedings in the context of an acrimonious divorce. So we say she has an interest hostile to the estate. We're just pausing there. That doesn't follow because she has an interest in preserving this estate for her benefit under the 75 Act claimant for the children. The idea that she would cut off her nose to spite her face is simply that's simply not substantiated. But the second point is that She's wishes and she has indicated that she intends to pursue those means of an inheritance act claim, which is entirely appropriate. Those are the two core reasons. That's the way the case is being advanced. Not there's a deadlock. Help. We need to resolve this in a neutral and unaccusative and non-hostile manner, and we've got some proposals. It is she must go. And yes, essentially, that is the key point I wanted to draw your attention to. Say, and I think you've already picked this up, your Lordship's already picked this up, is that what happens is we both open cost submissions, but it becomes apparent that we're not really ready to deal with it on the hoof.
Well, what happens is that the judge raises the possibility of appointing an independent person.
Yes.
There's a bit more toing and froing, and
Yes.
you go off and come back and agree that.
Yes. Essentially, yes. But then there's cost is outstanding. But it's just at A95. There's a bit to look at just at F, where Mrs. Justice Bacon says, "I'm wondering if the best way forward is for me to make this order, but without making the order for costs, to adjourn the issue of costs, because after all, save the cost with everything agreed. It seems to me that we need to make progress on the remaining issues. For there to be a court order drawn today which can enable the parties to move forward, then direct the parties should put in brief submissions on costs with provision for reply submissions, because actually the applications are effectively going both ways." And then she suggests the brief submissions with some page limits. Now, that is, I think, at that stage merely a suggestion. There was no objection in principle to that. The only objection that follows is the only difficulty was about timing. So there was no suggestion that there should be an oral hearing. There is no suggestion that there should be further evidence going in, or that the proposals for effectively limited submissions were objectionable. It was just about the timing. That's it.
And it was perfectly clear, because you'd spent several pages saying so, that your submission was going to be that they should pay the costs because they hadn't behaved very well.
Yes, and the indemnity point was
plus no indemnity.
Yeah, plus no indemnity. That's important because we flagged it. We flagged it.
So effectively, you'd signalled everything which the judge eventually accepted and made. But the point is, it didn't come out of nowhere.
Yes.
As far as
Browsers
were concerned,
they knew what was coming and what we were going to be addressing.
Had there been any doubt about it, they were disabused.
Indeed. So if I can it might just help to pick up my skeleton argument, which I'm sure has been read, but just to flag a couple of the key points of law. It starts at page A39 in the core bundle. Forgive me if I may end up jumping around a little, but I did want to look at at what I call my general comment section, it's A51, just setting out a little bit of the law, because I think it would help to just put this in context. The case I refer to at 40 is BCT Software Solutions Limited against C. Brewer and Sons, which deals with the situation where you have parties who have reached a compromise on all issues except costs, and how the judges should proceed in those circumstances. And I think it would be sensible to have a look at what was said in that, if your lordships aren't already familiar with that case. It is at tab 21 in the authorities bundle. The underlying facts of the dispute are not particularly relevant. There was I think it was a breach of copyright claim that was compromised on the second day of trial. And the judge was invited to and did go on to make a costs award, despite having not heard all the evidence. And Lord Justice Mummery, and it's at, I've got page 274 in the bundle, at paragraph 4 in the judgment. And really, it's from there and down until 9 is of key relevance. It says the arguments advanced in the appeal have demonstrated the real difficulties inherent in asking a judge to exercise his discretion in respect of the costs of an action which he's not tried. There are no doubt straightforward cases in which it is reasonably clear from the terms of the settlement that there is a winner and a loser in the litigation. And in most cases of that description, the parties will realistically recognise the results and costs will be agreed, and there's no need to involve the judge. If he does become involved because the parties cannot agree and ask him to resolve the cost dispute, the decision is not usually a difficult one for him to make. And so we say that is where Mrs. Justice Bacon found herself, when we had agreed everything except costs, and essentially were making cost submissions without the matter having been resolved at trial. Now he notes that there may be more complex cases, which we say this is not one, in which it will be difficult to decide who a winner or loser is. And it may be that there's a settlement in terms of a victory each way. And he says at 6, in my judgment, in all but the straightforward compromises, which are in general unlikely to involve a judge, is entitled to say to the parties, if you've not reached an agreement on costs, you've not settled your dispute and the action must go on, unless your compromise covers costs as well. And he explains that the good intentions of a judge in trying to help the parties to resolve are not always risk-free. But at 8, what he says is this, about this court is entitled to an approach and appeal against a costs order, which has been made as part of a compromise, with an even greater degree of reluctance than is usually the case when it's asked to interfere with the discretion of the trial judge. There's a piece in parenthesis that suggests it might even be that there's no jurisdiction to appeal, but that was rejected as a matter of principle. It says, if there is a point of principle in this case, which I very much doubt, it does not arise from the way in which the judge exercises discretion, but from whether he should ever embark on this particular exercise at all. As both parties agreed that he should undertake the task, it's reasonable to expect them to accept his decision, unless it can be shown that the result is, in all the circumstances, manifestly unjust. I would certainly not be inclined to interfere with the judge's decision simply because it's possible to detect imperfections in his approach or his reasoning. In my judgment, this court should only interfere with the cost order in this case if BCT makes out a case of manifest injustice. It has not succeeded in that, and the appeal was dismissed. There's Lord Justice Chadwick makes some similar remarks, particularly at 27. He says he shares Lord Justice Mummery's view that this is a case in which the judge could not have been criticised if he'd taken the course of essentially refusing to decide at all, no order as to cost. For my part, I think he would have been wise to do so, but it's not open to the appellant to complain that the judge set out to do what both parties had asked him to do. That is to say, to make an order about cost and to decide what orders to make on the material before him without determining the facts. So that's where we are, exactly where we are. That we have a case in which the matter had effectively settled and resolved by consent, apart from costs, and the judge was effectively invited to deal with the matter. She proposed to deal with it in a particular way in written submissions. Neither party objected to that, and it was put into the consent order.
You didn't actually read the next sentence.
Sorry.
Of Lord Justice Chadwick, which seems to me might be worth a moment's notice. Nor is it open to the appellant to complain that in seeking to perform that task, the judge adopted an approach which he himself described as broad brush. It's difficult to see what other approach the judge could have adopted.
Well, indeed.
In the circumstances.
Yes. So yes, quite right. I'm sorry. I should have read on.
And also the agreement of Lord Justice Brooke, who I think was in charge of civil justice at the time, agreeing with both judges.
Absolutely. That's just the sort of judgment we like to see. Yes. And so that is really where we are. So the idea that this case should have gone on to some sort of oral hearing, simply that was not on the cards. It wasn't suggested at the time.
Would have been on the face of it, that would have been the last thing in the world.
Indeed.
Which would be desirable in a situation where costs have already run up to an alarming degree,
yes,
and we want to keep them to a minimum.
Indeed.
But the other side of that coin is, inevitably, the judge is not going to have the benefit of oral evidence, cross-examination and so forth, or submissions on the facts, and
yes,
will inevitably have to take a broad brush approach.
and in this case, the judge was in fact able to look at the costs in a way that might well have been done by a trial judge who just made that decision at trial, because the costs arguments didn't really need to turn on. We didn't actually run arguments that there'd been misconduct insofar as misconduct is a matter of dispute at the trial. It was about the conduct of very much about the conduct of the litigation, which is exactly what trial judges would look at, but wouldn't have heard evidence on anyway. Whether
You would say it's all in the correspondence.
Indeed.
Exactly.
Yes. I mean, when a trial judge looks under their general discretion at costs and says, well, I want to know, was there pre-action correspondence? Was there an attempt to settle this? They won't have heard evidence on that. But they can still take it into account in the decision. And that's exactly what Mrs. Justice Bacon was able to do here, because we had the correspondence, because we could see exactly what had been going on, and we could work out the timeline. But moreover, the result, and I'll come on to the result, is clear. So when one looks at ground one, we say that there really is nothing in it. There was no procedural unfairness, because this is an entirely appropriate way of proceeding in the case. If the judge, she could have said, I'm just going to refuse to deal with it, but she didn't. She was invited to make a costs award, and the parties, you pay your money, you take your chance, really, in those circumstances. She gave directions, those directions weren't appealed. Those directions, as I understood it, were agreed. And it's not apparent what further evidence could have been adduced before the court. And certainly it wouldn't have been appropriate or proportionate to have had some sort of mini trial or contested hearing in which oral evidence was heard. So we say there simply is nothing in ground one. It's clearly not manifestly unjust to proceed in this way. It was agreed and in line with the guidance in the BCT case. Ground two suggests that somehow proceedings were needed, and therefore of some description were needed, and therefore it was not improper or unreasonable to have proceeded in the way that they did. And in fact, we're accused of having acted improperly and unreasonably, and not ourselves having pursued a claim, of course, at further cost. And we say this is simply divorced from reality, and that's why I've taken the court through something of the history of this claim to understand the nature of the claim that was put. The CPR Rule 44.24 says the court is to have regard to all the circumstances, including the conduct of the parties, which by Rule 44.25b includes the reasonableness of raising, pursuing, or contesting allegations or issues, and the manner in which a party has pursued its case or a particular allegation or issue. And so we say it is clear from that, if it's not, again, blindingly obvious, that when one looks at how litigation is being conducted, and from the cost perspective, one has to look at the actual claim advanced and the actual way it was advanced. It is no good saying, well, some sort of claim would have been needed. For example, if they both intermeddled, perhaps I should say, had acted before grant, and therefore could not renounce, so a court order was needed. Well, as I said, that can be done very, very simply. It's a straightforward Part 8 claim. We've come to this impasse, or we can't agree, we can't proceed, we'd like to stand down, we've got an independent person, here's their certificate of that they're prepared to act in a witness statement of suitability. That's a very, very straightforward application to make. And if the message to the court is the alternative is we're going to have a great big Barney with a whole lot of costs being paid because we can't agree between us, what is the court going to do? In fact, Mrs. Justice Bacon jumped at the opportunity when we said here's the solution. She jumped at it, and of course any judge in my submission would. And it's unrealistic to expect that a judge, given where the parties had got to, if that was the alternative, was a contested claim, would not simply have rubber stamped a consent order to that effect.
Right.
But of course that's not the claim that was advanced, and that's why I was at pains to take you through the claim that was actually advanced, which is for removal of Julie not just and not just that, but to confirm Mr. Bowser in his position, and not just that, but to remove her on an interim injunctive basis, which would put Mr. Bowser in control of the estate, as Mr. Justice Bacon observed, making potentially final decisions about the administration of the estate before actually the substantive matter was resolved. One has to judge the actual claim before the court, how it was advanced in fact, not the claim that no doubt he wishes with hindsight he'd advanced. Various authorities, you've been taken to various authorities. I mean, I think that the difficulty with these authorities is they do very much depend on their particular facts.
Well, we were taken to authorities, but Ms. Taylor expressly accepted that the judge applied the right test.
Yes.
So I don't know that authorities
yes.
are going to help us very much.
Yes.
Because the test is not an issue. She says the judge got the answer to that test wrong.
Yeah.
You say
no,
she didn't.
No, she didn't, indeed. So I don't want to.
So I don't know that looking at cases is going to help us very much.
No, all right. Well, I will move on from that in that case. The suggestion that my client is somehow to blame is an extraordinary one. She didn't ask to be sued. She didn't need to be sued. As I say, this could have been resolved by a non-hostile, very straightforward claim, if indeed that was necessary at all. There was the prospect that perhaps the parties could recognise they got off on the wrong foot and actually give this a go, had Mr. Bowser not been insistent on that she was conflicted in acting. There was at least that prospect, but it wasn't even attempted. She was told, do not act, in that letter of the 27th of June, and the next thing that happens is proceedings are issued against her. She puts forward a proposal. He could have accepted it. At any time, we could have put in once the proceedings were issued, we could have put in a consent order.
But it may be putting it a little high to say that she could have worked with Mr. Bowser, because from the correspondence it appears that she was at any rate under the impression, perhaps wrongly, that he had acted for Mr. Paul Taylor. That's said in one of the letters, and that might well have created difficulties in an ongoing relationship.
Well, interesting you should say that, Your Lordship, because of course that brings back in the question of those of the conveyancing file, because if in fact there was nothing to see there, that might have given her some reassurance. In fact, there was something to see there. I was going to deal with the ladder marshal stuff at the end.
No, by all means, that's fine.
I think
I wasn't thinking about that. I was thinking about one of the letters in the correspondence where she says precisely that.
Yes, there is a concern. There is a concern there, and she had suggested that someone else acted as well. Of course, the other point is that they could have worked together insofar as they needed to for a period of time, dealing with whatever the particular issues were. But it was never really given a chance. Once that letter of the 27th of June had come through, that was it. There was nothing more until the proceedings were issued. But, as I say, to blame her for pursuing the litigation when it was Mr. Bowser, who is a professional man, instructing his own firm of solicitors, who obviously are litigators, experienced in litigation, and have conducted this claim, they ought to have known better than to issue without attempting proper pre-action correspondence or ADR or anything of that nature. I will come on to the Bedo relief point, because I think that is a very important one. And I raise, in fact, I'll deal with that now. It's in my skeleton. I deal with the Bedo point. It's at page 52. When dealing with whether a Bedo application is appropriate, one has to understand the nature of the claim that is being proposed. And we say where you have a claim of this nature, which was a hostile claim, to remove one executor on the grounds of what effectively amounts to misconduct, that she's acting where there's a conflict, and or that she's acted inappropriately. For a trustee to do that, that is a hostile act, and ordinarily it can be equated with an application effectively seeking relief for breach of trust, and that's something that one has to be very careful about doing, and Bedo relief is appropriate in those circumstances. Now, I've given the court an extract from Lewin on trusts. It's at 30. It's quite a long one. It's at 31. Tab 31 in the authorities bundle. And in particular of 4880, and this is essentially at 378, page 378 in the bundle, and this is there's just been a discussion of effectively beneficiaries disputes and how trustees should deal with those. It starts at 372, proceedings for the enforcement of rights of beneficiaries against the trustee, and that might be whether by accounts, claims of money, breach of trust proceedings, 48068. But 4880 deals with a situation where it's the trustee who is the claimant. It says in case where the claimant complaining of a breach of trust is himself a trustee, for example, a trustee complaining of an alleged breach of trust by a co-trustee to which the claimant is not a party, or claim by the present trustees against former trustees, issues arise at the cost of both the claimant and defendant trustees. The position of the defendant trustees is governed by the principles stated above. In other words, he has some difficulty protecting himself, although it's not been determined whether former trustees who are unsuccessfully sued are entitled to indemnity. That's Julie's position, but this is Mr. Bowser's position at 081. Claimant trustees are in a somewhat vulnerable position as to costs, especially if they lose the action or obtain a fruitless judgment. The position here is somewhat analogous to third-party proceedings, and it is thought that the claimant trustees will be entitled to their costs so far as not recovered from the defendant trustees only if they've acted reasonably in bringing the action. That's the indemnity point. Unless the informed consent of all the beneficiaries or a suitable indemnity from beneficiaries is available, the prudent course is for the proposed claimant to make a Bedo application for directions as to whether they should sue. The issue in the Bedo application being whether it's in the interest of the trust fund or trust money to be spent on pursuing the proposed defendants. So the starting point is if you've got one trustee suing another effectively for misconduct, which is what this is, you ought to be getting Bedo relief.
Well, that's easier said than done, isn't it? I
Yes.
mean, it is quite a palaver, and a very expensive
yes.
one, and time-consuming.
Well,
It seems to me it's a sledgehammer to crack a nut in a case like this.
Well, yes, and that brings me on to the next point, which is that when one thinks, well, the thing about Bedo applications is they focus the mind. Because you've got to really be careful as a trustee in saying, is this really, you've got to persuade the court that is this really justified in the interests of the trust for me to pursue this claim? And that brings me back to the point I made right at the start today, which was to pursue a claim, a hostile claim against Julie was inevitably going to be expensive. It was going to incur costs by Mr. Bowser, it was going to cause Julie to incur costs. And if he wasn't going to pay the cost, one way or another, they were going to come out of the pot of money for the family. And it really does focus the mind. Is this really in the interests of the beneficiaries? Then one considers all the other things one does on a Bedo application. Consulting with beneficiaries. The court will want to know what's been done about pre-action correspondence, want to know what's done on ADR. All of these issues would have highlighted, in this case, would have highlighted the problem. Now, of course, one might say, oh, well, Bedo application, that's terribly expensive. Is it really justified in a case like this? And that simply, we say, just underlines the point as to whether this was the appropriate and proportionate way forward. If it doesn't justify the cost of the Bedo application, can it really justify the cost of the hostile litigation that's going to follow?
Well, it's because if you don't take out a Bedo application, then the onus is on the trustee to prove that he acted reasonably.
Yes.
In the event that he ends up losing. I mean, it's not
Yes.
as though you have to take out a Bedo.
No.
You're proceeding at your own risk if you do.
But of course, the alternative course, possibly in a case like this, where the trustee might have some doubt would be to take out a slightly different proceedings, which would be to say to the court, a problem has emerged, we are deadlocked, I need to break that. That might involve me standing down, it might involve her standing down, it might involve the court replacing us both. That would be a very much more neutral way of putting it.
I'm not sure in the light of also Wilkinson and Neary that is really open. I mean, that's rather what was tried on in that case without success before Mr. Justice Knightman.
But of course, this all underlines the key point in this case, that the costs simply did not make this a worthwhile exercise, because that option was always there. The simple solution, you get somebody independent in, you avoid all the litigation costs, save for possibly something very, very small, simply getting the court's approval of rubber stamping of that. And you can say to the court, the alternative is just so terrible because look at all the costs. Cost of bedo relief would be a factor. Cost of the litigation would be a factor. The risk of the litigation would be a factor. It just hones down into the unreasonableness of the stance taken in this case. If I can address the point on the point at ground 3 on success, and again, I had a little bit of case law on this.
I thought you'd done that.
Sorry. Well, I can. If I may, there is another little bit of case law on this, which is it's in my skeleton argument. Which is the case of Roach and News Group. It's tab 25 in the authorities file. But I've set out the relevant passages in the skeleton argument. This is Sir Thomas Bingham, as he then was. And he says at 168 in the report, that is 6, 7, 8. 318 in the bundle, I think. Right at the bottom. He says this: the judge must look closely at the facts of the particular case before him and ask who, as a matter of substance and reality, has won. Has the plaintiff won anything of value which he could not have won without fighting the action through to a finish? Has the defendant substantially denied the plaintiff the prize which the plaintiff fought the action to win? And again at just previously at 167, he talks about the rationale of failure to beat an offer. At the top of the page, the rationale of the rule is obvious. If the plaintiff puts the defendant to the expense of a trial in order to recover no more than he could have recovered without a trial, he should compensate the defendant for this unnecessary expense to which he's been put. This principle also is of fundamental importance in our system. A defendant cannot ordinarily prevent a plaintiff pursuing his claims, however exaggerated they may be, and may thus have a burden of costs in defending the claims thrust upon him. All he can do is to protect himself is to pay into court what is justly due, or what the plaintiff may prove likely to recover. If the defendant's judgment proves accurate, he will still incur the costs of his defence, but he can look to the plaintiff for reimbursement, the only protection he has against a burden of costs which might be quite literally ruinous. And we say that applies just as much for non-financial relief as financial. If one has put the proposal in, and that's what one gets at the end of the day, then that is where success lies. In a way, it's about drawing battle lines between the parties. That's how you judge success. One has to look at the claim that was brought. Did Mr. Bowser get an order for a grant ad col? No, he didn't. Did he get injunctive relief? No, he didn't. Did he get an order prohibiting the Julie from acting in the administration? Sorry, prohibiting her from acting in the administration and allowing him to act? No, he couldn't act. All that he got was an order that she be removed, and the price of that was him going too. He had to fall on his sword to get his reward. This can't even be described as a Pyrrhic victory. I mean, when King Pyrrhus of Epirus, his army suffered irreplaceable casualties defeating the Romans at the Battle of Heraclea and the Battle of Asculum, he survived the battle, but Mr. Bowser had to go. So we say this was not so much a settlement as complete capitulation. From Julie's perspective, she's made her position entirely clear. She would go if Mr. Bowser went. That's what happened. That's what she achieved. And going back to Sir Thomas Bingham's analysis, that result could have been achieved without all of those costs being incurred because she proposed it right at the start. That is a success from her perspective. Were these proceedings really necessary to retrieve that result? Again, it comes back to the point I've repeatedly made. No, they weren't. Different proceedings, if really necessary, at minimal cost, might have done so, but those weren't the proceedings that were brought. As for criticising Julie's conduct, that simply, it doesn't work when one reads the correspondence. And Mr. Justice Bacon's analysis of Ashton's approach in the correspondence to trying to resolve this is entirely right. Ashtons were virtually pleading with Bowser's to see sense. They denied that there was a conflict, and looking in the textbooks, they ought to have discovered that they were on shaky ground had they looked at that point. But were pleading with them to try to see sense and resolve this in a cost-effective manner in the interest of beneficiaries, but Bowser's weren't interested. They weren't interested in trying to resolve this. They simply wanted to push the case to court and insisted that Mr. Bowser remain. It's simply absurd to criticise her, or to criticise her conduct, or to suggest that she somehow has not assisted the litigation process. The matter was resolved at the first opportunity, but it could have been, the opportunity it reached court could have been resolved an awful lot earlier. And the suggestion, again, I think your lordships have the point that because we didn't put forward a proposal for a specific PR, that somehow we were standing in the way of that is just absurd. Mr. Bowser wouldn't agree the principle that he should go. So the question of who should replace him in the circumstances, who should replace him and Julie, simply never arose. Once he agreed to stand down, as he did on the day in November, finding and agreeing and identifying a suitable candidate was a matter of mechanics, very, very straightforward. Until you agree the principle, you don't come on to that question, and that's an easy question to answer. And in the event of dispute, the way I've done it before is simply to have somebody directed by the president of the Law Society, will simply appoint someone. It's mechanics. It's not a bar to settlement. And I think it is important to know how the case was advanced. This case was not advanced as a deadlock case. It was advanced as a conflict and breach of duty case against Julie. It may be convenient now to say, well, there was a deadlock. But if that was the case, then if there was a deadlock, the answer was rather to incur all of these costs was to simply stand down. The deadlock point is simply against my learned friend. That's how the case was advanced. It's even more incumbent on them to see the obvious solution to the deadlock. Ground 4 covers a number of procedural points. I've already dealt with the bringing and pursuing proceedings point. I think I've covered already. We did not support the issue of this claim against us. To suggest we did is absurd. She did not choose to be sued, and she ought not to have been. This matter should have been dealt with very simply and straightforwardly. And once they were issued, and hostile allegations were made against her of misconduct and conflict, she was entitled to defend them and to make a sensible proposal for their resolution, and that proposal is what ultimately won out. It's admitted by my learned friend that there was no letter before action. Mr. Justice Bacon was entitled to take that into account. The suggestion that there was no ample time to deal with matters pre-action is simply wrong. The letter on the 27th of June, so that's almost about 5 weeks or so before the claim was actually issued. Plenty of time to have engaged in pre-action correspondence then, especially if matters were so urgent that needed to be dealt with. Instead, what happened was Mr. Bowser unilaterally arranged the funeral in that time and secured witness statements from family members supporting him. Witness statements which promoted their continued running of the farm, not which suggested it was not financially viable, and certainly not which suggested that Julie would be moved back into the farm and that being the obvious solution for the benefit of the family.
And in the case of Paul Smith's statement, said not a word about the purchase he had made of the 2 properties in March.
Indeed. And so, again, reference to deadlocked weeks. Again, these weren't deadlocked weeks. The case was not a deadlocked case. Julie had been told to stop interfering, and she had. I've addressed the absence of bedo relief. As I say, I think the cost of the whole exercise, as I said, simply underlines the point that was never going to be an effective and appropriate way of proceeding. One had to look. Cost was absolutely critical, and if there was a low-cost way of dealing with it, it was always to stand down. I should deal with the conflict of interest point, because we say it's very clear from the textbooks that there is not regarded as a conflict of interest in these situations, and my learned friend tries to argue something rather different conflict effectively now. There's some conflict as a result of the fact that the claim is against beneficiaries, and that she couldn't act as litigation friend for them. That's certainly how it was put before Mrs. Justice Bacon. And Mrs. Justice Bacon was quite right in saying, well, that's just a non-issue. That's never how the conflict had been advanced in the case. The conflict was supposedly between Julie's position as claimant and as PR. There was never any question of Julie acting as litigation friend. She doesn't act as litigation friend, of course couldn't act as litigation friend. But that's an entirely different conflict.
May it not be the position that Julie was, in fact, in the position of conflict, which made it probably desirable that she should eventually, or she should step down, as indeed she herself offered to do.
Yes.
The reason, though, is not because she was, or not just that she was bringing a 1975 Act claim, but rather that in the administration of the estate there were urgent matters that needed dealing with to do with the farm, and in relation to the farm, there was obvious difficulties caused by the fact that
yes,
there were 2 camps, as it were. There was those who were actually sitting in the property and using it, including Jack, the eldest son, and the grandfather who was helping out and so forth.
Well,
how could she, as an executor, conscientiously deal with that kind of a situation, where she had a personal interest, one might imagine, in seeking to say the property should be awarded to her under the 1975 Act?
Well, the difficulty that Jack, the grandfather, and Lorna have is only Jack is a beneficiary of the estate, and only to the extent of 10%. Yeah. They are none of them executors. They had been there, presumably with Ian's permission at the time. They are effectively there as whatever license they had to be there had expired, and they were simply the people on the ground dealing with it. Now, if there had to be decisions made about the farm, the obvious question was how to preserve this for the benefit of preserve the value, essentially, for the benefit of the family. And Jack acting, what in fact we know is that Jack was running this butchery. I didn't take you to the full section in Mr. Bowser's witness statement where he explained. I probably ought to. It is at. Is it paragraph 14? It's A109 in the core bundle. Mr. Bowser says, the second very obvious problem is that Mrs. Smith is living with her 9 children in a rented property, whilst the 7-bedroom farmhouse built by the testator to house his then wife and family is only being lived in by Jack Smith and Mr. Smith Sr. Finding a solution to that problem will not be easy. If there's any way that allows Jack to carry on his fledgling business, his business, that's the butchery business, not an estate business, assisted by his aunt, Miss Hayes, and his grandfather, Mr. Smith Sr., then it needs to be looked at carefully and dispassionately. Well, I'm not sure that's right at all, because this is a business that's being carried on estate land by Jack, who's only a 10% beneficiary and has no beneficial interest in the land whilst the estate is in administration, is highly unlikely to ever achieve an award that's going to allow him to run a butchery out of the farmhouse, a converted room in the farmhouse. And we say, really, Jack's position is untenable.
Well, how do we know? We don't know
Yes.
enough about the facts.
Well,
it's quite possible if it's a big enough farmhouse, it might be. And after all, he's a beneficiary. One of the things that has to be considered under the 1975 Act is the position of the beneficiaries.
But if decisions had to be made about the farm,
my point is, though, how could Julie do that dispassionately when she herself had a very clear interest in obviously seeking the whole farm for the occupation of herself and the 9 younger children?
Well, seeking the farm for the occupation of herself and the 9 younger children is one question. There's a slightly different one, which is the duty of the interest, and that's what she would do in the 75 Act claim. But as far as her duty as executor is concerned, it's simply to hold the ring and preserve the position as it is.
What if the question arises as to whether Jack should be told to discontinue the butchery business, which after all is what
yes,
your client was apparently also insisting on?
There's two issues there. One is, at what stage does that arise? It doesn't necessarily arise at the outset. It might be that you resolve the 75 Act claim first, and then it all falls away. There was no necessary. It wasn't at that stage. Certainly, we were interested in getting Julie into the farm, but it doesn't necessarily mean that she can't act as PR at that stage. If a conflict of that nature arose in practice, then that would have had to be addressed at that time, and that might be that she stands down. But it seems that Mr. Bowser, from what he's saying today, also supported bringing Julie and the children into the farm. The other possibility is that directions could be sought on that issue, possibly alongside, and the obvious place to do that, if it got to it, was as part and parcel alongside the 1975 Act claim. So it may be that particular discrete issue is one that could have been actually resolved without the need for her to stand down. But she wasn't conflicted per se until that conflict it actually arose in practice, and it hadn't done. She might have been in a position where she had to stand out. But as she said, and it comes back to the point, that she had agreed to go. So if we got to that stage, yes, her position might then have become untenable, but it certainly wasn't untenable to start with.
Yes, I think perhaps all I'm saying is her agreement, her expressed willingness to stand down may in fact have been very sensible. Bearing in mind the potential for conflict that existed in a situation where the main asset in the estate is the farmhouse.
Yes.
And on any view, it's giving rise to difficulties, and where there's an obvious conflict between her interest as a claimant on the one hand, and the wishes of at least some of the beneficiaries or wider extended family on the other.
If that conflict had reached a point at which that issue had become pressing, as I say, she's only hopefully about to move back into the house now. And that's as a result of proceedings outside of the Chancery Division. Then there might have been an issue there. But as I say, there were other ways potentially of resolving that. And one doesn't sort of throw the baby out with the bathwater and assume, well, just because there's one issue that might be problematic, that there's a necessary conflict and she has to go. But if and when it had arisen, which it hadn't at the stage at which we reached, then that was something that we'd have had to have looked at and sought and worked out how to resolve it. Julie going might have been one of the solutions, but as it is, that didn't arise because she did agree to go. So there might have been that, but as I say, we didn't actually get that far. But the mere fact that she is I think when one reads the passages in the textbooks, we're squarely there. There's no difficulty in procedure. In this case, if, let us say, Julie was the sole executor, what would happen in a 75 Act claim is she would issue the claim as claimant in her personal capacity. But she would also be a party with her hat on as executor for the purpose of binding the estate. Any other PR would effectively be a defendant to ensure that all PRs are represented in the estate is bound. But they would remain neutral, save to the extent that they have to provide information. That's pretty much their only task under the practice direction. And then you have a claim which effectively runs against the beneficiaries, who would be represented in this case by the uncle Peter Cross. He's got solicitors on board. Jack and Joe, if they want to bring solicitors on, they could. But
yes, but if you have a person like Julie who is wearing two hats, one as beneficiary claimant and the other as PR, albeit wearing both hats as claimant. I mean, surely there's a conflict between her personal interest, which she's doing her most to promote in one capacity, and her duty to remain neutral as PR on the other.
Well,
And it seems to be obvious in that situation that the estate needs separate representation.
If we look at I think that the point is that the estate simply takes a neutral role.
Well, I know it does, it's supposed to, but I mean, how can a single person be both neutral and a claimant fighting her corner?
Insofar as she is representing the estate, all she's doing is providing information. And if you have a co-trustee, co-executor, then they can fulfil that role too.
Yeah.
I think we do need to look at the provision on this. So 28 is the passage in the White Book. Tab 28. And it's page 340 in the bundle. And it's 57.16.1. Point 1. Where a grant has been obtained, the personal representatives are necessary parties to the claim. The taking of a grant by the claimant is no bar to an application under the Act. An application under the Act does not impugn the validity of the grant, or will, if any. And that's obvious. There is no need for a spouse or civil partner to renounce probate or the right to letters of administration if such a person wishes to claim under the Act. The personal representative may, in that situation, still be the claimant. There's no need for the same person also to be joined as defendant in their capacity as personal representative. They talk about the possibility of a person bringing proceedings in one capacity against themselves in a different capacity and some of the other commentary. And it explains that any other personal representative should be joined as a defendant, and at least one of the main beneficiaries should be joined at the outset.
Yeah.
Here, and it's pretty clear who would be joined. So the White Book has no difficulty with it. If one looks over the page to tab 29, and it's page 348. This is an extract from Francis on the Inheritance Act claims, practice, law and procedure. And if we go to page 348, and it's 35, paragraph 35. And it's about halfway down that paragraph, and it starts 1, 2, 3, 4, 5 lines down. There is no difficulty merely in a person being both a claimant in a 1975 Act claim and a personal representative. Since the claim is not in substance a claim against the estate, the claimant is not suing herself.
Sorry, I can't find this.
Sorry, page 348.
348.
Sorry,
My fault.
it's 30. There's 35 in square brackets in front of it.
There we are. Yep, got it. Thank you.
It's halfway down. It's about 5 lines down.
Yep.
There's no difficulty.
Yes, so there's no difficulty merely. I mean, that's rather the point. It all depends on the facts as to whether in practice there might be a difficulty, depending on the nature of the estate and the situation on the ground. I mean, that seems to me the problem in this case.
Well, that might arise if, I suppose, I mean, Julie's interest in preserving the estate does not conflict with her preserving the estate intact in terms of its value. Certainly does not conflict with her claim. It's in her interest as much as it is in her children's interests.
She might have a strong interest in preserving it in species, so she could have a house to live in with the children, rather than, for example, having it sold and transformed into cash.
That may be quite right if we got to a stage where that was being proposed. But I think at this stage there was no proposal that it be sold. And certainly if there was a disagreement between the beneficiaries as to whether it should be sold or not, then that might be the case. But on the fact of this case, none of the beneficiaries have ever suggested that they want this sold as a whole. Jack seems to think that he wants to farm this in his father's memory. That's all over his statement to Mr. Bowser's statement. So he's pro keeping the farm. Julie wants to keep the farm. There's no suggestion from her that it be sold. In fact, there's very sound commercial reasons why she should keep it. And if one's seen the valuations, the farmhouse is valued at about £250,000 in itself. It's a 7-bedroom property. My understanding is that effectively it was a small, possibly a chalet bungalow that's been extended. But it works for the family. But to find equivalent size of accommodation in the local area will be hugely more expensive than that, is my a 7-bedroom property, because essentially, as I understand, it's in the middle of nowhere, down a rough track. It's been built by Julie and Ian. It's the valuation evidence I think is there. You'll see it. It is in the bundle.
Yeah.
It's not in great nick. So there is actually a real impetus in them. It's far better to stay in a property that serves their needs and is cheap than have to sell even more assets to buy an equivalent sized property elsewhere. So there is a huge impetus in keeping the farm from her perspective. And similarly, this is farmland that can, much as it hasn't been profitable, there are things that one can do with farmland, even if it's simply to let it to another farmer at rent. This business may not have been making money, but the land certainly can. So I don't think there's been any suggestion from the perspective of the beneficiaries and from Julie that it be sold. If that were to be an issue, and the PR was saying, I'm going to sell and therefore prejudice your position in the 75 Act, then that would be, I agree, a very difficult situation. But that's not where we are. So I think it's the difficulty with conflicts is one has to wait until they actually cause trouble before you really need to deal with them. And in this case, we haven't got to the stage where trouble is being caused by any conflict. Indeed, it could well be, or could well have been, that the matter will simply be resolved amicably outside court fairly promptly. Once we know the outcome of this appeal, once we know to what extent the costs is going to be a liability for the state. Actually, then I think we're pretty much ready to go as far as getting this into mediation is concerned.
Right, now, how much more have you got? Here we are having a whole day's argument.
No, indeed.
Appeal. Let me finish.
Yes.
Here we are having a whole day's argument in the Court of Appeal
Yes.
about a matter which you dealt with in 3 pages below. So I think we need to get on.
Yeah. So yes, well, I would just very briefly. I've given you also the passage in Ross, which deals with the same point on conflict. I was briefly going to come back on the Ladd and Marshall points, if I may.
Yes.
And I think the problem my learned friend has is she's whether she intended to do so or not, I don't know, but she's almost conceded the point by accepting that there is the prospect that there's a benefit that this property that's been sold off there could be a beneficial interest, there could be a trust in place, and that's obvious. If this transaction was a sham and no consideration actually ever really did change hands, query where the title has gone. And we also say that if there's a transaction at an undervalue, it certainly can lie in an executor to be looking at whether that was in fact a transaction defrauding creditors and to unpick it. So there are claims that an executor might well have to be making. Whether or not that would actually extend to a claim against Mr. Bowser, I don't know. But to suggest that there's no claim that could be brought is simply wrong. And then when one looks, I think we don't actually need to look at a couple of bits and pieces in the file. So if your lordships take up the Ladd and Marshall, the applications bundle, and it's at PSG, it's PSG1, it's at B14 is the start of the exhibit. No, I'm afraid there's not. This is not got pagination at the bottom. It's B14 is the exhibit, and the conveyancing file starts. It's at B26. That seems to have been overlaid by a 12 on mine. But B26 is a letter to Mr. Smith from Mr. Bowser. Of the 7th of September, so he's writing directly to Mr. Smith there, informing him of the registration. I think your lordships have already seen the AP1 document, but just in case, it's at B34 is the relevant section of it, under box 13. It says where the application is sent to the land registry by a conveyancer, and one sees name of transferor, landlord, transferee, tenant, borrower, lender, and you've got there the transferor Ian John Smith and transferee Paul Anthony Smith. In the guidance note, it says place X in the box in the second column if the person or firm who is sending the application to the land registry represented that party in the transaction. Otherwise, complete the details in the third column. If the party is not represented, insert none in the third column. And we can see that both Ian and Paul's names are crossed. So that's a direct representation that they were both represented by Bowser's, Mr. Bowser in particular, as the partner who had conducted this, in that transaction. Otherwise, if Paul Anthony Smith wasn't instructing them, it would have said none in the third column. Also, B38, this is the bill for professional services to Mr. Smith, but it says at the top, payable by Mr. P.A. Smith. Again, there's a letter at, just back on page B37, I enclose a note of my firm's charges for work done, which is payable by your father. So, for Mr. Bowser to say he wasn't acting at all in this when they've represented to the land registry that he was, written to him on the basis that he was, and have billed him for the work, is concerning. B39, there's a memorandum. I now return the TR5 having witnessed Ian Smith's signature. He's also confirmed his father, Paul Anthony Smith, will want Bowser's to make the AP1 application, and I enclose his ID. Which rather suggests that he was to act. So we say, much as the conflict in relation to that transaction, which we say is significant, rises from the fact that Mr. Bowser was involved, irrespective of whether he in fact acted for Paul. There is a very serious question as to whether he did. And the problem with all this is it asks so many questions. There's obviously something odd going on here. We say Mr. Bowser, simply on the basis of this documentation, Mr. Bowser is in an invidious position, because if he is having to pursue a claim on behalf of the estate against Paul Smith to say, well, in fact, that transaction was a sham or at an undervalue, and we want to try and set it aside, that he's in a hugely compromised position. How on earth can he say to Paul Smith? Paul Smith will say, well, what on earth were you doing acting on this transaction if you didn't think these loans were real or valuable, or you thought this was a transaction that's an undervalue? He is placed in an impossible position. Of course, Mr. Green can do that. He is neutral. But even if my learned friend is right and there's further inquiry is needed, that simply yet again underlines our point that costs being expended on these sorts of issues is hugely problematic for this estate. It's yet more cost which the beneficiaries, on her case, are going to have to foot, which can all be avoided if Mr. Bowser is prepared to stand down in favour of an independent person.
I suppose there may also be questions of privilege. Legal advice was given by him in his capacity as solicitor to either Paul or Ian Smith, which he may not be allowed to know about in his capacity as a PR. Absolutely.
And of course, the point is, if he's got to investigate that, we don't know what he knows or what he doesn't know, and it's all very well for him to say, oh, well, there isn't or there is. He's just placed him in a completely impossible position. And he must have known about this. We asked, you'll have seen from the correspondence, we asked specifically for this file, and it wasn't given to us. That was before the hearing. His position really was untenable. And in the circumstances, it simply, as I said in the schedule, it just underlines every single point as to why it was so important that this was dealt with. One, properly pre-action, so these issues could be flushed out and flagged and the problems identified. Two, that proper ADR was undertaken in which the consequences of this could be understood. Three, the legal shakiness of an application to remove my client alone whilst keeping him in position where he had this conflict was going to be of serious concern. But ultimately, it comes back to that commercial point I made at the beginning, that any cost of this litigation was always, it was going to be paid by the estate or by Julie, it didn't matter, it was going to come out of the pot available for this family, this grieving, vulnerable family. And it was only going to get worse as these issues flagged up, as the issues became more complicated. And it just shines such a pinpoint of light on the obvious solution, which was staring everyone in the face, right, and should have been from the outset, which was that he goes at minimal cost without the need for this highly aggressive litigation. I'm very conscious of time. I've bored your lordships for too long. If I may just turn my back to see if there's anything else I need to cover.
Yes, thank you.
Thank you. That's my submissions.
Thank you very much. Mr. Green, I know you're neutral, but I don't know if you've heard anything that causes you to depart from that position, or whether you need to say anything.
My lordships, my lady, I think I would only check that you've had the opportunity to review my note and the attachments, which are in the application bundle.
Yes, thank you.
Sorry.
Yes, we
Yes.
have. Thank you.
In which case, I'm not proposing to take you through that. You've read it.
No.
The only matter I would highlight is that the additional valuation evidence which I handed up to the court this morning, in essence, has added £86,000 to the bottom line. So if my note is read in that light, that there will be an additional 86 based on the valuation evidence I received late yesterday. So that is the only correction to that.
Yes.
Regarding the other matters, your lordship anticipates my position, which is one of neutrality. There are matters which obviously I hold opinions on, and matters I have seen. I think I'll go no further than this, which is to say I am here today to assist the court if there are specific questions that you have regarding any of the particular issues. I shall be happy to respond as best I can. But I don't think it's for me to go on a free-range commentary regarding the parties' positions.
No, quite. All right. Anything you want to ask? No? Well, thank you very much, but
Thank you.
we don't have any questions for you.
Thank you.
Yes, Ms. Taylor.
My
a
lord, can I
reply.
trouble the court? I hope to be 5 minutes.
Very good.
I appreciate the court has been taken to matters in great detail already. Firstly, what I would like to do is to take the court to A110. This is part of Mr. Bowser's witness statement in support of both the claim and the application. And at paragraph 15 at the top of that page, I just invite the court to note that there really were difficulties that Mr. Bowser, as the professional executor, had trying to get hold of the lay executor. She made it clear she did not wish to have further contact with him. She wishes to have sole control of the winding up of the testator's estate. Apparently this is on the basis of legal advice she has received from her divorce solicitor, Mrs. Pearson. This unreasonable refusal to communicate with me means there's no practical way in which we can administer the estate together. So I'd invite the court to note that point. On the following page, A111, subparagraph 4 of paragraph 16, much criticism has been made of Mr. Bowser in relation to the funeral arrangements. His evidence was this, that he had real difficulty with Mrs. Smith in relation to this as well. Not that he was simply unilaterally and arbitrarily saying, I'm going to organise his funeral regardless of what you want, but he had spoken to her, he'd suggested the undertakers, that she was going to give all the instructions and she required a burial, that she wasn't coming to the funeral. It's actually the other way around from the way it's been presented to the court. It was actually Mrs. Smith saying she was going to do it unilaterally, and Mr. Bowser pointing out that he should be involved. And then, of course, got into the maelstrom of the family having different opinions. So I'd invite the court not to conclude that Mr. Bowser was being unilaterally and arbitrary in dealing with the funeral. There was also the point which I made to Mrs. Justice Bacon that the body was decomposing and a decision had to be made. At page A112, if I can take the court there, paragraph 17. The professional executor's legitimate concern that there was a conflict Further, she has made it very clear, dear Lord, let my lady see that. Further, she's made it very clear she's not going to consult and can discuss matters with my firm. I've referred to the early problems we've experienced. I'm concerned they will multiply and get worse if Mrs. Smith continues as an executor. She was clearly in a hostile position with regard to the testator prior to his death, and this has not changed. And that, in fact, was borne out by the witness statement that she put in answer, which is, I won't take the law, your court to it, but it begins at B50 in the call bundle, and it begins with 3 pages, in effect, 8 paragraphs relating to relationship with the testator. Now, there's no criticism made of her, given that the testator died right in the middle of acrimonious divorce proceedings, that should be her mindset. But since it was, that was an additional problem for Mr. Bowser. I would also like to take the court to the transcript of the application hearing, which is A73. And really to develop the discussion that Mr. Justice Henderson had with my friend in relation to conflict in the day-to-day decision making, and I did make submission in relation to that. At D, Mr. Hicks read what I said in relation, but that was only.
Sorry, what page?
I'm sorry, A74.
Thank
my
you.
lady. I'm sorry. A7. I'm sorry. I'm going too fast. I'm trying very hard not to overstay my time. Mr. Hicks took the court to the section at D, and that was where I began. I did manage to get my first reason out before Mrs. Justice Bacon wanted something else to be addressed. But at F, I dealt with the other things. And in relation to the proceedings having commenced, that was the 875 Act proceedings, which was Mr. Bowser certainly hoped would be resolved amicably, not least because it was clearly a meritorious claim. But what he says here is what I submitted, and this was the confirm. Those relate to the role of personal representative in the proceedings. They do not refer to the day-to-day administration of the estate, which is where we say the conflict of interest arises in the management of the estate, something which you may want on everyday decision-making. There are real problems with this estate. I'm sorry it's so incoherent, and I hope I've been more coherent today. Because there is a farm which may not be profitable, and so on and so forth, a farmhouse which she might want to occupy, which might need to be sold, and so on and so forth. And it's important in most of these situations that she should be performing her fiduciary duties in the interest of the estate, and not prioritising her interests as the claimant or potential claimant in 1975 Act proceedings. So it wasn't just in relation to those proceedings, but the potential conflicts and the day-to-day issues in relation to the everyday administration of the estate. And whether or not the discussions had been entertained about whether the property should be sold, it's obviously one of the things that happens in the administration of an estate is that assets are sold. And it was really difficult in this situation where there was a non-profitable farm and whether it could be sold separately from the farmhouse would be an issue. It hadn't been discussed, it hadn't been raised, it wasn't possible because of the breakdown in the relations between the parties. But nevertheless, it was an issue, and it was quite possible that because of her claims, Mrs. Smith might not be thinking in terms of what was actually right for the beneficiaries, but might be thinking in terms of what was right for her as a claimant under the 1975 Act. And the last thing I would like to draw the court's attention to, much has been said about the letter of the 7th of June being the first and perhaps best letter, and much has been said of everything having gone downhill from the letter of the 27th of June. So I'd just like to point out to the court with respect on page B130, which is the second page of that letter of the 27th of June, that there is a heading there, way forward. To move matters forward, we invite you to a meeting, so there should be a you. We invite to a meeting with Mr. Bowser at our Wisbeach office of 15 South Brink. We need to arrange this meeting as soon as possible, as there are various matters to resolve urgently relating to the business and Mill Hill farmhouse. Now that offer was not responded to. Matters descended a little because the funeral took place on the 21st of July and no steps were taken then. But I would just like to point out to the court that right from the outset, efforts were made and a meeting was suggested, and this was against the background of the 10th of June telephone call where Mrs. Smith had said she wanted to take charge of the sole charge of the funeral, and the 14th of June where she said she'd been advised by her divorce solicitors not to talk to Mr. Bowser. And 2 weeks after that, he's still saying, well, come to the office and we'll talk. This was not responded to. That is entirely consistent with the advice that she'd received from Dak Pearson, that she should not speak to Mr. Bowser. And of course, the next thing that she did say on page B131 was a proper letter from DP Legal, that's saying again that Mr. Bowser shouldn't act, and then him saying, well, I'm the only appropriate director of Bowser's that can handle the administration of his estate. There isn't anyone else. So I would just like to highlight those points. Of course, I would reiterate all the other points that I've made in support of Mr. Bowser earlier. With regard to the Lad and Marshall, in effect, the evidence is in. But what I would say in relation to that is that I opposed the application on the basis that it was put, which was that it could have had a major influence on Mrs. Justice Bacon. And I say that issue really hasn't been addressed by Mr. Hicks. What he's done is he's taken into the facts of the transaction, possibilities, conveyances, duty, possible, all those things. But he hasn't really dealt with why it should be received by the Court of Appeal now, today. I leave it as it is because, in effect, we've all looked at it. And it isn't a new issue. It's an issue which was raised by Ms. Stevenson in I think, her first serious letter. I can't take it any further. Safe to say this court can't make any decisions on it because it's contested evidence. And whether Mrs. Justice Bacon could have done, bearing in mind that it was contested evidence, is also a moot issue. My lords, I don't want to take up any more of the court's time unless there's any other matter that I haven't covered. But what I don't want to do is kind of leave a lacuna, some issue that I haven't covered that the court would be.
I think you've covered the ground.
I hope so.
Yes, I think so.
I hope so. I've covered it at a gallop, and so yes,
Well, nonetheless for that.
there may be some holes in the turf.
Yes. All right. This may not be a question for you. It may be more for Mr. Hicks or Miss Green, but it occurs to me. There's something said about mediation being teed up once the outcome of this appeal is known. Don't tell us anything confidential, but can you tell us any more about that?
I think what I can say is that dates are being looked at, but the impression I have that people need to wait for this to be resolved so that they know where they stand in terms of the assets in the estate. But
yes, I see.
Burkitt Long are acting for the minor children. I don't know where Jack and Joe stand at the moment, but there's no reason because fortunately yesterday we had the up-to-date valuation, so I really think we are in the home straight in lining that up. Hopefully in the next couple of months.
That's helpful to know. All right, well, we're going to rise, but we will come back in a few minutes and see where we are. Rise. Which? Oh yeah. Ching, ching, ching.
And that's what
we have reached the clear view that the appeal should be dismissed, and that is the order that will be made in due course. That will be for reasons to be given in writing, and there will then need to be consequential submissions following on from that about what should happen in relation to the costs of the appeal. Those submissions will be made in writing and dealt with without a hearing. I would just add that we have been told that there is, now that the result of the appeal is known, some possibility of a mediation taking place to resolve outstanding matters. That is a course which we would strongly encourage those concerned to take part in. It seems, although it's not before us, that there is no real dispute in principle that there is a valid 1975 Act claim which Julie has. The family needs to be housed. We don't know, but there may be a claim in relation to the properties transferred, which were the subject matter of the fresh evidence application. And it seems to us that it would be in the interests of all concerned, which not sure exactly who that might mean, but it would seem to include, if I can use first names, Julie, Jack, the other adult child, those representing the minor beneficiaries, and possibly even Paul Smith, if there is a claim in relation to the transferred properties. It will be in the interest of all those to resolve matters without further legal costs, in view of the needs of Julie and the family, and the modest nature of this particular estate. It seems to us that the urgent course is the way forward, rather than recriminations about the past. As I say, I don't know the details of who would need to be involved in any mediation, but in this kind of case, that is likely to be a far more effective way of resolving matters, much more so than further litigation. And I say this so that that message can be conveyed as being the view of the court to all those who may need to hear it. So far as the mechanics going forward are concerned, the draft judgment, when it is ready, will be sent to those whose contact details have been provided. As you will appreciate, it is at that stage subject to an embargo, which the court takes very seriously. We will then invite submissions as to costs and so forth, as I said earlier, and deal with that, hopefully in order for that to be dealt with and an order available when the judgment is handed down. So thank you all very much for your assistance. That concludes the hearing of the appeal.
Bye.
That's congratulations. I'm just busy closing. Honestly, me and Ted.
Well, you know,
Anyway,
that's, thank you very much. Well,
See what they make of the judgment. See if he uses my